should be on.
Okay, yeah.
That is? Oh, yeah.
Yep, whenever you're ready.
Okay, great. Good morning, everyone. My name is Avi Cover, and I'm here today, hopefully you're all here for the same reason, to talk about the Trump travel ban. And in particular, oral arguments will be before the Supreme Court 1 week from today. So exactly in 1 week, the court will finally resolve the legality of the travel ban. And the case, as all of you may know, at some level, involves some critical issues for our country. It really gets to the heart of how are the borders controlled, issues relating to security, issues relating to immigration, and on the other hand, issues relating to civil liberties, individual freedom. The role of the courts. This is sort of a classic separation of powers case. What's the role of the president in this? What is the role of the courts? What is the role of Congress? And so today I want to talk about really the nature of the case, the arguments made by both sides. I won't be so bold as to venture a prediction, although I'm happy to engage in a conversation, and I think we may be able to divine some indications of where the court is going, both in terms of what the Supreme Court has even done relating to this case over the past year, and then, of course, look at some critical precedents, some critical earlier cases, which to some extent are captured in issues of plenary power, Lyndon B. Johnson, Belgian Marxists, and animal sacrifice. So I promise to deliver on all of those points. However, some of you may be uncertain as to what travel ban the Supreme Court is going to decide. The case that will be before the court is called Trump versus Hawaii. And this isn't the first time that the court has sort of delved into and addressed Trump versus Hawaii. In fact, as some of you may recall, you may have a little bit of deja vu, didn't the courts already deal with the travel ban in some respects? And really what we're talking about, of course, today is travel ban 3.0. So, the concern is always the third sequel is usually, not all that good. And particularly when you're looking at a sequel, you really want to know, what happened in the earlier versions. So I think it is a little bit important and incumbent upon us to go back almost a little bit over a year ago when President Trump, 1 week into his presidency, issued what we'll call Travel Ban 1.0. Or his first executive order. So some of you may recall, let's see if I can get this to play, it did seem like every day, no, I'm not going to get it to play. Okay. At the very least, there was an incredible amount of protest immediately after that first order was issued. And some of the issues relating to it, if you recall, was it was a ban that went into immediate effect. There was no notice of this order. It applied to 7 countries, as you may recall, Iraq, Syria, Iran, Sudan, Libya, Somalia, and Yemen. It applied to nationals who had already been issued visas. It applied to lawful permanent residents. It applied to dual nationals. There was an immediate suspension, indefinite, of all Syrian refugees. And there was even a provision that made for an exception for religious minorities in those countries, which was understood to be essentially Christians in all of these majority Muslim countries. There was no interagency review, as is usually the case for an executive order. And there were even typographical and policy-wise inconsistent components of the order. And as you may recall, as sort of in this image is depicted, right, people fled to the airports, lawyers were there. There was certainly a fair bit of chaos. It seemed you would turn on the news every day, and there was another district court enjoining the travel ban from going into effect. And by the spring, in fact, the order had been enjoined across the country. And quickly thereafter, that order was essentially recanted, retracted, and we go to, the sequel, Travel Ban 2.0. which in many respects wasn't really all that different. What you saw was it changed a little bit of the countries. Iraq was no longer listed as a country, given the United States' relationship and security cooperation with it. The lawful permanent resident ban was taken away. There was an interagency review. There were more exceptions and waivers allowed for it. But Travel Ban 2.0 was also rejected by the courts. Almost every single court that addressed both 1.0 and 2.0 struck these down as illegal, and they enjoined them. These are all at a preliminary injunction stage and a nationwide effect. Finally, just in September of this past year, President Trump issued Travel Ban 3.0. Has a long name. It was the Presidential Proclamation Enhancing Vetting Capabilities and Processes for Detecting Attempted Entry into the United States by Terrorists or Other Public Safety Threats. A mouthful. And the president, not so distinct from the earlier iterations of the order, essentially relied on his power in the Constitution to suspend entry of a variety of nationals from entering the country, and relied on the Immigration and Nationality Act, in particular sections 1182F and 1185A, and basically held that immigrants and non-immigrants from these respective countries could not enter the United States, that their entry would be detrimental to the interests and security interests specifically. Now, this order, in contrast to Executive Order 1.0 and 2.0, did change up the countries. While 1.0 and 2.0 had been all Muslim majority countries, you'll see here on the list of 8 countries, there are 6 Muslim majority countries. North Korea and Venezuela are not Muslim majority. Chad is just barely majority, and all the others are over 90% Muslim-dominated countries. We'll get back to the significance of that. I have chosen for the purposes of this talk to use the term travel ban. Some often will call this ban the Muslim ban. And so this order was issued. There were far more findings of security concerns. The way this order, the history behind this order, and again, in contrast to travel bans 1.0 and 2.0, were that the State Department actually sent out requests to all the countries of the world and essentially said to their various consulates, how are you vetting the individuals who are seeking visas or seeking entry into the United States? And they had a set of criteria that countries needed to meet to give assurances that there would be sufficient security. And there were baseline issues in terms of no identification of individuals, et cetera. The government found that about 16 countries had not met these criteria, were unacceptable. They remonstrated with them. There was some consultation. And ultimately, these 8 countries were still found lacking in these security criteria. And so here is then your list. There was an interagency review. There were a lot more changes that went on for this order. So specifically, what also happened here wasn't quite the same blanket ban. There are some exceptions for individuals from some of these countries. Again, exceptions include lawful permanent residents, people who had been admitted into the United States before the effective date. And there were sort of case-by-case waivers that were permitted that had not been permitted, particularly in Executive Order 1.0. So those, again, are the respective countries. There were some surprises. Chad, in particular, had been a country that cooperates a lot with the United States in counterterrorism operations. And the nature of this order reads in such a way that theoretically the government could revisit the criteria that these countries are using in terms of screening and vetting, and people from these countries could be permitted in. It's probably important to note at this point, North Korea, in contrast to most of these countries, the year prior to this order going into effect, had 13 individuals seek entry into the United States. So not necessarily so much of a security concern, it would seem. But here are the 8 countries nonetheless. So the issues then before the Supreme Court. What's the court going to decide, right? As I've mentioned, often the criticism of this order has been that it is a thinly disguised Muslim ban, right? And we'll talk a little bit in particular about what then candidate and on the campaign trail Donald Trump said with respect to a Muslim ban explicitly. And so in essence, that's really this tension. Is this a legitimate security measure that is taken by the President of the United States, consistent with statutory authority and constitutional authority? Or is this something motivated by religious animus, by hate? And it is really just transparently that, in violation of both statutory authority and the Constitution. And so the issues before the court will be, the court determined these are the issues. One is just simply justiciability, right? Can they even hear this case? Do the individuals have standing? Is it appropriate? Is it prudent for a court to intervene, and in particular, an immigration-related exclusion issue? Issue 2 is basically, does the president have statutory authority to do this? And did he execute it properly or effectively? That's the Immigration Nationality Act question. The third issue before the court is the Establishment Clause. Essentially, was this an action by the government that disfavors Islam, disfavors Muslims? And then finally, can courts be issuing these global injunctions, right? Can one court in one district issue an injunction that's going to affect the entire nation and affect the entire immigration policy? While all 4 of these issues will be before us as I chat with you today, I'm going to focus in particular on issues 2 and 3. Right, whether the president really has statutory authority to do so and has he executed properly, and whether this is constitutional, whether the travel ban is constitutional. It's always helpful. I teach at Case Western Law School. We work on briefs. I work in a clinic, so I'm always pushing my students. How are we going to open our briefs, right? How are we going to, this is important. What's the core theory of the case, right? How do you distill it down? So I thought it'd be helpful to take a look at the opening sentences of both the government's brief and the state of Hawaii's brief, the plaintiff in here. So the government, which is the appellant in this case, they lost in the Ninth Circuit below, reads as follows. The exclusion of aliens is a fundamental act of sovereignty that rests on the legislative power and is inherent in the executive power to control the foreign powers of the nation. So there it is. That's it. Distilled down to the essence. This is what presidents do, right? It's inherent power to determine the borders, issues of security, and it comes from the legislature, right? This is it, right? Very clear. Power is located in the president, and really, in essence, courts should stay out of this. And it follows in the next couple sentences. And presidents have done this for time immemorial, right? Not a big deal. This is ordinary. On the other hand, as you can imagine, the state of Hawaii has a different view. The president's order is without parallel in history. For over a year, the president campaigned on the pledge, never retracted, that he would ban Muslims from entering the United States. And that following sentences go on to say, in fact, that this will affect 150 million people, mostly Muslims, and the Constitution and statutory laws do not give the president such power. So this is it. These are our 2 polar extremes that the lawyers will be arguing in a week before the court. And so I want to go in now into a little bit more detail. I'm going to look through the briefs, look through the arguments at the various stages, watch some of the oral arguments at the lower court levels, and want to share some of that with you. So first, the government side of things. The government is arguing. How many people here remember Youngstown? Maybe from con law or the steel seizure case, right? Okay. So in essence, one of the government's arguments is, as sort of that opening sentence suggests, when Congress authorizes something and the president acts per that authority, the president is acting at the height of his power, right? And so the steel seizure case, which came out of the critical provision here, is from Justice Jackson's concurrence. This was about President Truman actually not far, just down the road in Youngstown, seizing the steel power plants for the purposes of the Korean War. And Jackson formulated this rule, essentially, that if Congress has acted in this area and the president acts there, the president is pretty much good to go, all right? It's at the height of his power. So that's the president's first argument here, that it's authorized by the Immigration and Nationality Act, and here's the president acting in that capacity. And so courts should really just butt out, and at the very least must give great deference to the president's actions here. We're dealing with national security, immigration, critical pieces. And most importantly is this notion of plenary power. So plenary, right, is full, complete power. Where do we get that from? And where does the president get that from is perhaps even the more important question. Well, in Article 1, right, which remember is the Congress's power, the Congress has the power to establish a uniform rule of naturalization. Right? So from that, we've taken to understand that Congress has power over all of immigration. And over the years, that policy has rang true. Now, it's not always, of course, a particularly pretty power. In fact, the Supreme Court, in one of its really less stellar moments in its history, just a few years after the 14th Amendment was issued, dealt with the Chinese exclusion laws. And the Supreme Court upheld a congressional act prohibiting Chinese laborers from entering the United States who had departed before the law went into effect. I just want to read a little bit from that court's opinion. This is from 1889. The Chinese remained strangers in the land. There's almost echoes here of Book of Exodus. Residing apart by themselves and adhering to the customs and usages of their own country. It seemed impossible for them to assimilate with our people or to make any changes in their habit or modes of living. Their immigration was in numbers approaching the character of an Oriental invasion and was a menace to our civilization. Those laborers aren't citizens of the United States, they are aliens. That the government of the United States, through the action of the legislative department, can exclude aliens from its territory is a proposition which we do not think open to controversy. If, therefore, the government of the United States, through its legislative department, considers the presence of foreigners of a different race in this country who will not assimilate with us to be dangerous to its peace and security, their exclusion is not to be stayed, because at the time there are no actual hostilities with the nation of which the foreigners are subjects. Its determination is conclusive upon the judiciary. So court has nothing to say here. That's the court actually opining, right? It's okay, purely on the basis of race. Doesn't matter that there's no hostilities in place. We are unnerved by these strangers. It is absolutely within the province of the legislature to do so. I give you the origins of the plenary power doctrine, right? Which says Congress has that sort of power. And that idea, I'm sorry?
Was it a unanimous vote?
I can't say for certain, sir. I don't want to misstate. But that is certainly, at the very least, the majority opinion. And it is something that in various iterations we have seen that power, and this is also, of course, a question. That's Congress's power. So where does the president get this power to act with respect to immigration? And so in some respects, there's always a question of sort of delegation to the president. Can the president act in his executive capacity to execute this plenary power? And there is some dispute about that, but in many respects, he does. And particularly when immigration, issues of race, issues of non-citizenship come to the fore with issues of national security. And so then you see, of course, a ruling like Korematsu, right, which upheld the concentration of some 140,000 Japanese Americans, right, where even the lines between nationality and ethnicity and race can be confused. So that's plenary power, though, right, which suggests a really incredible reach of authority that is really almost limitless and taken to its full height. And so, that is exactly, in fact, just a few years ago, the court ruled when the state of Arizona wanted to issue certain restrictions, making it harder for non-citizens to travel in Arizona. The court ruled in sort of a protection of civil liberties to say, no, state of Arizona, you can't interfere. This is plenary power. This is the area where the Congress can authorize. We control the border, right? Oh, sorry. Congress controls the border, right? Not states. And so there's that clarity of that line. And so it's that notion of plenary power then that you meet here, where the president is given power by Congress under the Immigration and Nationality Act, that the president makes his first argument really for the power to issue the travel ban, right? And it says, whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. So, I know for some of you that might be the first time you're reading these words. At the very least, not just at first glance when I read these words, I say, well, that seems pretty clear then. Right? The president has the authority then to issue this sort of travel ban, right? There would seem to have been a finding, right, as I just laid out in Travel Ban 3.0, that individuals from this country haven't met certain security requirements of entry into this country. So it would be detrimental to the interests of the country. The president, right, this statute gives the president the authority to do so, and has suspended the entry, right, has prevented that entry. These are the restrictions that the president has the power to impose. We'll get into, because of course there is another statute which would seem to, in some respects, contradict some of this. But that's at the heart, right, the first argument of the president. Look, statutory grant of authority, plenary power, game over. And in fact, the Ninth Circuit only dealt with this issue. It actually didn't even deal with the constitutional issue. So the case really came down to this statute and one other provision in the Immigration and Nationality Act. Now, just to preview for a moment some of the things that both the Ninth Circuit and the state of Hawaii took issue with in terms of maybe why the travel ban doesn't fit within here. And any statutory constructionist here who might find some language in here that doesn't seem to be giving quite as wide berth to the president as he might claim for power here. Any potential words of limitation here?
Detrimental.
Detrimental. Okay, so what does detrimental mean? And so indeed, one of the questions about the findings is to what extent, what level of specificity do you need to show in terms of detrimental? Any other words that maybe jump out? I mean, connected to that is just the finding. I mean, were there sufficient findings? The other is suspend, believe it or not. The notion would be is that it should be temporary. And the nature of this order, even though I suggested to you that there's openness to potentially those rules changing, is there is no time definite given in the ban, right? It would seem to be indefinite, and that suspension can be read as inconsistent with that, and particularly for such period as he shall deem necessary as well would seem to run afoul of that. But I think if we look at this in isolation, this seems like a pretty strong argument. If we think about congressional plenary power, giving this power to the president, that looks somewhat problematic. One thing, some of you might remember a concept of non-delegation, maybe from administrative law. Right? There is one notion of actually this is too broad a power to give to the president. Right? That is to say, the Congress cannot abdicate its responsibility and give the legislative function to the president. And so that this is too broad a power to give to the president. Whether you buy that argument or not, that's also one that is made. The other thing the government relies on is to say, remember I read you that provision where it suggests never in history has this ever been done. The government calls into question that. They say, oh yes it has. Just go look at President Reagan, President Carter. And there are a couple of instances, and there are other instances, of course. President Obama, President Clinton, both Bushes did issue executive orders limiting the entry of nationals into this country. It's been done over 40 times. These two stand out because they addressed a much larger swath of individuals. President Carter, you can imagine, what country do you imagine Carter issued a ban of sorts on? Iran, precisely, right? So in keeping with the Iran hostage situation, Carter responded, and depending on it, I will say, it seems to me if you read both briefs, you can read histories that seem to disagree a little bit, but some pretty broad scope of Iranians. It seems there might have been some exceptions, people would argue. But in response to the embassy taking and hostage situation, did issue that order. President Reagan, anybody remember or know when President Reagan did this? With Cuba. There had been a dispute over actually immigration, and there started to be illegal immigration that Cuba was essentially encouraging into the United States, and so Reagan issued an order banning again. There's some point of contention, but certainly a very large group of Cubans, right? So government argues, hey, we're just in the great tradition of these two presidents acting this way. The arguments on the other side are that this ban is far broader, that those were more specific, and they were directly responsive to sort of a crisis moment. That's some of the distinction. Again, as I mentioned, there have been scores of other bans, but they are usually to a very specific identified group of individuals. So, for example, President Obama, I believe, issued one to the Al-Quds forces, right? So to a specific Iranian guard of individuals, right? Particular individuals identified for violating human rights, right? But never sort of entire populations of a number of countries. So again, that is a fight that is had over past practice. So that's the issue of the Immigration Nationality Act provision. Let's turn to the constitutional argument, so the Establishment Clause. Here, we need to meet our Belgian Marxist. This is academic and journalist Ernest Mandel, right? Pretty big name here in Cleveland, Mandel. I don't believe any relationship. But he was a communist, wanted to come to the United States, had come to the United States previously to advocate and spew views about communism. And a number of professors, crazy radical communist professors, I guess, American professors, wanted him to come again, back to the country and visit and speak. Well, when he tried to get into the country, he was denied. He had previously violated certain rules on immigration, and so was being denied on those technical grounds. In fact, he wanted a waiver. You could get a waiver for advocating communism and world revolution, but he was denied that waiver because on an immigration technical violation. And the court ultimately ruled, look, those grounds seem legitimate and bona fide, right? We're not going to look at, the professors argued, we have a First Amendment right to hear from Mr. Mandel, right? We have a First Amendment right to hear about communism, we need to learn, et cetera. And the court basically said, look, you might think this is a First Amendment violation. We're not going to even reach that because there are legitimate and bona fide reasons as to why you're keeping this individual out. So we can avoid the constitutional issue, right? And we don't look behind the reasons, all right? So remember those words, legitimate and bona fide, and we're not going to look behind. We don't care about the other reasons, right? There's enough on its face to keep Mr. Mandel out. We don't need to address these other issues. And that is a big theme that the government argues throughout. In this immigration context, when the government wants to exclude people, right, courts should be exceedingly deferential, right? These individual decisions about a person, right, courts don't have anything to say. It's a fairly routine matter. The law is very clear. The executive branch is making a determination based on that law. Courts should stay out of it, all right? And that's the government's argument in a nutshell. The plaintiffs argue, of course, quite differently. So I'd mentioned the state of Hawaii is the named plaintiff, but there is also an imam here in the middle, Dr. Elstik, I believe is how you pronounce his name, There is a Muslim organization that is also a plaintiff in this matter. And their primary claims, just to make it clear, right? Hawaii is arguing, right? What's its injury? What's Hawaii's injury? Why does it have a claim? How is Hawaii adversely affected by this travel ban, do you imagine?
They want the people to come in to be doctors, lawyers, scientists?
Sure, they want, right. So they are missing out on people from any of these countries, right? Significant restrictions, if not impossible, for some of those people to come work in Hawaii. Mr. Witch, where are you going in 4 weeks? Hawaii, right? So what are they missing out on? Tourism, right, from these countries, okay? So that's their injury. Right? That's Hawaii's injury, right? We've got a brain drain, money, right? All of these things, right? Dr. El-Sheikh has family members who cannot come to visit him, to be with his family. His family cannot be together because of this ban. That's his injury, right? He also argues that he is stigmatized. The Muslim community argues they are stigmatized by this ban. And that's part of what the association argues. And members can't come to join their organization. Right? So that's the injury, right? That gets a little bit to the standing that if time permits, we'll talk a little bit about. So as you can imagine, the plaintiffs have a very different view of both the Immigration Nationality Act and the Establishment Clause claims. And theirs, I began with sort of some of that wretched history that we don't like to talk about in terms of U.S. immigration policy, right? So we talked about the Chinese Exclusion Act. Of course, there were quotas, right? There were quotas up until Lyndon B. Johnson in 1965, where you would say, right, X number of people can come from this country, and X number can come from that country. And it wasn't just, although it was most notably a ban on individuals from Asian countries, but of course there were quotas and limitations on Eastern Europeans, on Italians. Certainly, people invoke the World War II Holocaust history as some of those immigration rules as keeping Jews who were fleeing Nazi Germany from getting into the United States. Well, with Brown versus Board in 1954, and probably in part and then Kennedy's passing and the Civil Rights Act passage in 1964, by 1965, the United States gets its act a little bit in order on immigration issues. And in the Immigration Nationality Act, Lyndon B. Johnson signs into law getting rid of these national quotas. Right? And essentially now you will have more of a merit-based, family-based immigration policy, right? Which is, of course, right now very much in dispute, right? But what it did do away with was the national quota aspect and the inherent racism that was often involved in that, and xenophobia. So that, of course, is the spirit and message that the plaintiffs invoke and bring to bear here. But it's not just some halcyon view of history and romanticizing Lyndon B. Johnson and the Immigration and Nationality Act. There is, of course, a statute, right? I mentioned to you that there is what would seem to be a contradictory statute at issue in the Immigration and Nationality Act. And it reads, "No person shall receive any preference or priority or be discriminated against in the issuance of an immigrant visa because of the person's race, sex, nationality, place of birth, or place of residence." So I think my next slide is even, in fact, yes, right? The two statutes next to each other. Let me just take first for a moment the second one. So on the face of it, this second statute that the plaintiffs rely on, 1152A, would seem to call the game in favor of the plaintiffs. Right? You can't preference or prioritize or discriminate against people on the basis of nationality. Isn't that what the travel ban is? It says 150 million people from these countries can't come in. Yes, sir?
Is it the second statute, though, does that apply to people just in the United States, or does it apply to people that live in foreign countries?
So it applies to people in foreign countries. It's about, but I think what you do touch on, and maybe is the important point to make, and what the government makes a lot of, is discriminating or preference or prioritizing against them in the issuance of a visa, right? Whereas the first provision talks about entry, right? And so is that a distinction with a difference or not is one of the very issues that I can promise you the justices, will be hammering both sides on Is this a distinction that matters? So it does apply, sorry, sir, let me just make clear. It does apply to people outside of the United States, 1152A. And it would seem to be, and it was one that came in 1965 with Lyndon B. Johnson signing, that would seem to say, no more discrimination, right? That was the purpose here. But again, one of the big issues here that the government says makes all the difference, and the plaintiffs and respondents argue doesn't have a whit of difference, is this entry versus issuance of a visa, right? Is this a distinction or not? And so, I think reasonable minds can differ on that. I mean, one argument would be that 1152 would be made meaningless if you could have a ban on discriminating on the basis of visa, but then you could discriminate on the basis of entry, right? How could those two be reconciled? Is at least one argument. Yes, sir.
They seem to be dealing with different things. I mean, the first one's dealing with the entry of a class of aliens. The second one is dealing with no person should be deprived because of discrimination. I mean, they seem to be dealing with different problems, different groups of people.
Because of the use of the word person versus alien?
Person versus the class.
Versus class, yeah.
So, for example, in the second case, the person can't be discriminated against, individually. Okay, that's different than saying that a class of aliens is found to be dangerous to the United States.
Yeah, so that I think that very much fits within one of the government's arguments that they are making, that this is a distinction. One argument that's made the other way is that 8 U.S.C. is more specific, and so that the specific should control over the more general, whether you buy that argument. It is a later in time statute, and so one argument is, of course, in terms of statutory construction, that the later in time statute should be given greater weight. But I think there are very fair arguments to be made, and as I suggest to you, this will be very much one of the conflicts before the court. How do we make sense of these two conflicting, apparently conflicting authorities? And so they fight over this in their briefs as well. Let me take you to the Establishment Clause argument. So remember, the government basically says that we don't even really need to look at the Establishment Clause argument. I should also add, they essentially say, since we're dealing with an immigration national security context, don't bring in the domestic Establishment Clause. It doesn't really have much bearing or application here. Needless to say, the plaintiff respondents have a different take on this. And this is where we come to our animal sacrifice. So there is a remarkable case, some of you maybe studied in constitutional law or have had reason in some of your practice to come across it, called the Church of the Lukumi Babalu I versus the city of Hialeah. And so this is the case. The Santeria faith, part of their faith involves animal sacrifice. And they moved, the community, a significant number of members of the church moved to Hialeah, Florida, and had every intention of practicing, which would include animal sacrifice. Well, there were a fair number of citizens, and I guess council members of the city of Hialeah, who weren't too pleased about this. And they passed an ordinance, which essentially said, you cannot have any animal sacrifice in the city of Hialeah. So what's the problem with that?
Infringing on the religious
Infringing on religious rights would seem to maybe be a free exercise or even Establishment Clause violation. And the argument was made by the city of Hialeah was, no, this is a neutral rule, right? There are problems with animal sacrifice, health, safety, right? We can imagine maybe some of those issues. And the court said, hold on, we're not going to just take this neutral argument. We need to look and see, is it really neutral? Right? Is it really just about health and safety? And they started looking at it, and it seemed to be very much what, I mean, I guess I've sort of buried the lead, so to speak, was really only about the Church of the Lukumi. It wasn't about anything else. And so there were exemptions made for kosher slaughterhouses, right? There were clear suggestions that hunting, right? Because they wanted to actually, the language is, I'm not giving you the full flavor of the language, but it was sort of like, no animals should be killed cruelly, must be for purposes of consumption. So how did hunting, somehow get permitted? And so there were all these carve-outs. So the court said, no, we need to look. We're not going to just accept on face value that this is neutral. We're going to look. We're going to look at the context. We're going to look at the text. We're going to look at the legislative history. We're going to look at the words of the members of the council, which, let me just give you a little bit of a flavor. various Hialeah city officials made comments such as the chaplain of the Hialeah Police Department told the city council that, at the city council hearings before they passed the ordinance, that Santeria was a sin, foolishness, an abomination of the Lord, and the worship of demons. We need to be helping people and sharing with them the truth that is found in Jesus Christ. The community will not tolerate religious practices which are abhorrent to its citizens. So the court, looking at all of that, said, no, this is clearly aimed at a religion, disfavoring a religion. And so there's still going to be, by the way, that doesn't, you have to look, compelling interests, right? It's going to be a strict scrutiny, though, instead of just sort of accepting it. And ultimately found that this ordinance was unconstitutional. So why does this matter? Why would the plaintiffs cite Hialeah and the Santeria church case? Well, the commander-in-chief, and when he was a candidate as well, was known to tweet a fair bit. And a fundamental part of his campaign was calling for a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on, right? This becomes sort of exhibit A for the plaintiffs. No, you can't accept that this is a neutral ban seeking to accomplish security interests. We need to look behind, right? We're not going to accept bona fide and legitimate reasons on their face. We have enough reason to think that there's something else going on, and maybe it is religious animus. What's one problem if you're the government you're going to argue with this? I mean, there might be more than one. Yes, sir. He wasn't president. I mean, come on, right? Like, what kind of rule of interpretation is this? You're going to go back to, government leaders when they were 8 years old and the things they said, right? What's the statute of limitations here? Well, I think that's a very fair argument and a debate to be had. Needless to say, the plaintiffs' respondents, President Trump tweeted when he was also president, not just a candidate. And so has looked at other things. This is from June 2017, when the cases are being argued. You got to feel for the lawyers. People, the lawyers and the courts can call it whatever they want, but I'm calling it what we need and what it is, a travel ban. Then, right when it was going up to the Supreme Court, the travel ban, and as they issued, just a week before they issued Travel Ban 3.0, the travel ban into the United States should be far larger, tougher, and more specific, but stupidly, that would not be politically correct. So, again, the government argues we should look at Hialeah, right? We need to go back and look at all the president's comments, and the argument is essentially, look, what might appear to be a neutral ban to you is not that, right? That it is motivated by animus against Muslims. And you should look at other criteria as well, and so there are arguments made. For example, one of the amicus briefs points out that there has not been, of the 8 countries represented, there has not been an individual from any of those countries who has committed a terrorist act on US soil since 1975. Or another fact they argue is actually the incarceration rates for members of those 8 countries that are the subject of the travel ban is actually lower than the countries' incarceration rates for other countries. So arguments of, and then of course the argument made that this is hardly a narrowly targeted ban, right? If the goal is to stop terrorism, you are keeping out every individual from these 8 countries, 150 million people from this country. There have to be narrower ways to target terrorist attacks. And of course, I mean, there is a very wide, expansive immigration system by which individuals are checked and vetted is one of the arguments. But so, and this is, to be sure, a contentious issue that the court, I think, will also engage in. To what extent do you look at the tweets of a president? Right? I don't know that will be a new sentence written in the Supreme Court annals. Does it matter? Right? The government would argue what? What do you imagine the government argues? Aside from saying we can't look back at obviously the pre-presidency tweets and statements. Sir? So, I mean, I suppose that's absolutely right. He certainly has the freedom of speech. I guess the question is, what can be divined from this, or what can maybe temper the significance of these comments?
There was a study done in the third case that they did a worldwide analysis of the problem.
Exactly. So the argument is like, you know what? Whatever the motivations, even if you decide that President Trump was motivated by religious animus, there's been a study there have been findings. There have been cabinet officials. There's been an interagency task force. Are you trying to impugn the work of the entire federal government here? Right? So they have done these studies, and notwithstanding whatever the motivations were, right, there has been this finding, and then it should be given some level of deference, right? And so there should be at least that analysis, right? So that's the key argument that I think is made. I think the government's argument, of course, is a little bit of also like, and you shouldn't look at those comments. I think there is a quality of sort of like, don't look behind the curtain, you kind of do know those comments are there, and I think it will be difficult, for the justices to balance those out. Just a couple, just ending comments on this, and then I want to open it up to questions. So one issue is, I guess maybe I will touch a little bit on a prediction. So it's important to note in December, the Supreme Court stayed the preliminary injunctions that had been issued by the court. So essentially, the lower courts had essentially enjoined this whole ban from going into effect. And the Supreme Court stayed it, meaning the ban has been in effect, right? Let the ban go into effect. And so some people might read into that, well, I mean, if you recall, the preliminary injunction standard is one of them needs to be likelihood of success on the merits. So if the court stayed the injunction, one interpretation, certainly by some court watchers, is, if they thought back in December without so much briefing that they were going to lift or they're going to stay rather the injunctions and let the ban go into effect, that suggests some openness to the ban's legality. It was a 7-2 ruling. It's not even actually necessarily clear whether Justices Sotomayor and Ginsburg, who did not join it, dissented or just didn't join it. So there's 7-2. So there is some reason to think that there's some significance there. The other is that I think no matter how critical you are of the ban, it's hard to dispute that it is an improved, more sensitive, more thought out, does have findings supporting it. There are waivers. It's not quite as massive an action as versions 1 and 2 are. And so, one notion might be that will both maybe just on its merits alone might mollify at least 5 members of the court and say, yep, this is okay. But also, and I think in some ways maybe is the larger message that a lot of observers of these issues have thought about, which is that in some respects you could say the last 15 months show how our system still works, even in however you might characterize as crisis, right? The court stepped, and no one of course is happy in those situations, right? The president acted, at least by one account you might argue, rashly, impetuously, racially, religiously, with a religious animus motivated, and the court stepped in. And they tempered executive action. And the president tweaked it, and they changed the law. And then the court stepped in again, and they changed it again. And so there has been an improvement. So you could see this as like a very nice, I don't want to play the violins too much here, but a nice story, right? The system works, right? All the branches had something to say and do. Although you might argue Congress really kind of stood on the sidelines, as is its wont, right? But that the order has been changed in significant ways. And so, now at least we see some, development there. I don't know that I subscribe to that view. I just want to put it out there in terms of, whatever side you're on or whatever you're thinking, you don't need to be on a side by any means, suggests some difference and change. I will say, it's an important thing that, unfortunately, again, I have to harp on how difficult I think President Trump does make it on both maybe members of the court and certainly his lawyers. Even during this whole process, President Trump has not done himself any favors by attacking judges. And so, when the first injunction was issued, the attack on another branch of government, I don't think is something that is lost on the members of the Supreme Court. And in fact, I just want to actually note this quote. This came from last year. This is, by the way, a very conservative justice writing who dissented from an earlier Ninth Circuit opinion on travel ban version 1.0, I believe, right? So he believed it was legal, but he felt the need to write in his dissent, and it was joined by other conservative members, that these sorts of attacks on the court are unacceptable and really do undermine the rule of law. And so I think those actions, that conduct, will be something that the court will be mindful of. I don't know that they will speak to that issue, but it is certainly, it is, to quote Marbury versus Madison, right? It is emphatically the province of the Judiciary Department to say what the law is. And I don't think they like being told that it's not. With that, we have about 10 minutes. Happy to entertain any questions or engage in a discussion on any of these issues.
Yeah, just one comment and one question. The comment is, it appears that the president did this, made all these comments and did all this stuff, and then afterwards, he had very good lawyers come up with reasons why what they did was correct. I doubt if all that analysis you went through happened before he signed that order.
Well, I mean, that might be the case. I don't know that that's so unique about law, right? I mean, not to trivialize anything, right? But something horrible happens, a gun attack, right? Immediately, I'm like, let's figure out a way, depending on what your view is, right, to eliminate guns, right? That's your first instinct. Now you're going to need to figure out how is that legal, and oh, there's a Second Amendment. What do we do about that, right? So, and in fact, post-inauguration, Rudy Giuliani was on one of the Sunday news shows and said exactly that. The president asked me, how can we make sure a Muslim ban is legal? And I believe it's actually in one of Trump's tweets. He essentially says, yeah, we figured out we're going to use country instead of religion. We'll use territory, I think was the word. We'll use territories instead of religion, and it should be okay. Right? And that's sort of the simplistic soundbite of tweets. That's the danger of them, right? So, yeah, undoubtedly. I mean, that's, assuming we're all lawyers here, that is part of what I suppose lawyers do, right, for their clients. And so I think that's some of what is going on. I think what it gets to is still that essential question. If you posit, right, and that again the motivation is Islamophobic. Does that mean the game is over, right? And I think the other arguments in terms of if there can be neutral reasons that could support that same ban. How might the court deal with it? I assume the court is going to do its utmost to avoid this issue. I will say what's very intriguing, as a little inside baseball, is there were two appeals coming up, the 4th and the 9th, when the Supreme Court stayed the injunction of the ban, right? 4th and 9th. And it said, 4th and 9th Circuit, get your opinions in really fast so we can review them. Well, the 9th Circuit got its opinion out in like 2 weeks. The 4th Circuit, unfortunately, took 3 months. Or 2.5 months. And so only the 9th Circuit opinion is being reviewed, and the 9th Circuit only addressed the statutory issue. It didn't address the Establishment Clause issue. And so what was a little unusual was when the Supreme Court said, here are the issues we're going to address, it put on the Establishment Clause claim. And so, it's a little bit surprising because, A, there's a notion of constitutional avoidance, that the courts don't want to address a constitutional issue if they don't have to, and it wasn't decided below by the 9th Circuit. But clearly, notwithstanding my thought that they might not want to wade into those waters, they may feel they need to, given that they made it one of the 4 issues.
Okay. Now, my question is, and you touched on this a little bit, but I wonder if you could give more detail. Since the ban was, the injunctions were lifted, what has actually happened? I mean, before that, there were huge protests, there were people complaining, there was articles in the paper, and there's been almost nothing.
Yeah.
Yeah. Are there still things happening out there?
I mean, the short answer is yes, there absolutely are. And I think more in terms of the attention and issue speaks to, I think, I mean, we live in frightening and exciting times, I think, and so, I think there's only so much that the news cycle, seems to bear. But one aspect was, particularly immediately, and it speaks to the especially problematic aspects of the first order, was that it was done without notice. Various government branches didn't know what was going on, or executive branches didn't know what was happening. And so there was really this chaotic element. There were people coming on planes who weren't, by the terms of the order, allowed to enter the country. Whereas there was notice here, and so there has been, some, if you will, accommodation, acclimation to the current situation. But individuals are being kept from their family. The state of Hawaii is missing out on tourists. I mean, they would argue the injuries are ongoing.
But did you say the government has been making some exceptions?
Yes, so there are very few though. I mean, in fact, I think I read in one of the briefs. I mean, I think there had been very few. I don't want to give a number and misstate something, but there's been far fewer waivers than I guess, was anticipated by the plaintiff's side. Yes.
So, I don't remember the case of Babalu and City of Hialeah very much, but is there going to be, do you think there's going to be a different treatment because of the actors in this situation? The city council is kind of lower level and the president is so high.
Yes, absolutely. So very good question, very good point. Yeah, I mean, the government argues, I mean, first, like, we shouldn't even be dealing with Babalu, like that it's apples and oranges, right? That's a domestic case. We're in a national security immigration context. So first, just the context should matter and distinguish and say we shouldn't be looking there. And you couple that with, you're absolutely right, the president acting, the executive branch acting, that an exceeding level of deference is due here. I mean, to the point where, again, as I say, they argue there shouldn't be any judicial review and shouldn't look behind, right, these legitimate and bona fide reasons. I mean, that's sort of where we get with the Mandel case, the Belgian Marxist, right? You shouldn't look behind. And I should have noted there was an opinion from just a few years ago, Justice Kennedy, always the linchpin. He, in a case where a woman, I forget if it was her husband or her fiance, was not allowed into the country on immigration grounds relating to terrorism. And she wanted, essentially, like, he didn't get sufficient due process, et cetera. The court ended up rejecting the claim, but Justice Kennedy said, we will normally accept a legitimate and bona fide reason unless there's some affirmative showing of bad faith, right, was Justice Kennedy's concurrence. And so, needless to say, the plaintiffs harp on that language. And they're saying, like, well, bingo, right? You need to look behind here. The affirmative showing of bad faith, see endless stream of tweets by president. But I think you're right. I think the court, and it's amazing, you can have a court, like, in one opinion say, immigration and national security never mean that we ignore people's individual liberties and constitutional claims. That said, a lot of deference is owed to the president, commander-in-chief in his capacity here, therefore, you lose. I mean, and I mean, that's not to be too cynical about the way the ruling and language can be. But I do think that would be an important thing that the government does distinguish, and I could see the court buying into that argument very much. Time maybe for one more question? Sir.
If the court rules on the very first issue you listed, the judiciary,
Yes.
the rest of it gets all thrown out, right?
That's right. That's right. No, absolutely. So the court could rule just on the justiciability ground that, forget about those three questions that we've, have to hear about in CLEs and people have briefed, hundreds and thousands of pages on. And it could be on any number of grounds. It might not buy into the standing argument. There's one aspect we didn't really talk about. The constitutional and statutory claims are being brought by the individuals here in the United States for other people, essentially, right? So some people might argue, and this issue, I don't want to get too standing technical, but are they in the zone of interests and et cetera? Like, who suffered the injury? Can you bring those types of claims? That's one argument. And the other sort of ties more into a sort of Administrative Procedure Act. But is there really an injury claim here? There's a doctrine of consular non-reviewability. So I think I mentioned a little bit earlier, when the consulate makes a determination in another country that person X can't come in, there's a notion that the courts won't rule those individualized determinations. And so one of the arguments the government makes is, well, it's just like this. The flip side that the plaintiffs argue is no, this is not an individualized determination. It's a huge policy determination that deserves judicial review. The flip argument might be on the other side, is not a whit of difference. There still shouldn't be a review. So yes, that could be the case. And then who knows what happens on the injunction piece in terms of, that really goes to, the argument on one hand that an injunction should only affect the individuals concerned. And so issuing a nationwide is just gratuitous and superfluous. The argument on the other hand is, no, our immigration system is huge and all-encompassing, and you can't have a disparate immigration system with different rules in different places. At any rate, I think the oral argument should be fascinating. They'll hopefully be available to listen to, within 24 hours. And I think we should expect a decision by, the last week of June, probably the last Thursday of June. We'll get a ruling in this case. But who knows? There are very much, related issues that are maybe on fast track to the court that aren't so distinct. Rulings about sanctuary cities, about DACA, that really touch on a lot of these same issues that I think the court will be dealing with in the not too distant future. Thank you very much. Have a great day, everyone.